Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? Welcome back to another week here. It is Monday, and we're looking forward to a nice week. And unfortunately, for some of you that hate me drinking coffee during the video, it's 2:30 p.m., which is right in my afternoon coffee time. So there will be some of this, and there'll be a lot of legal talk as we discuss this Parkland shooter trial some more. As interesting as it was, while we were watching the hearing together, there was a slip up by the judge that I thought was not great. She did walk it back, and then she did berate the defense a little bit outside the presence of the jury. And unsurprisingly, the defense has filed a motion to disqualify this judge. I've had questions about that. I've had questions about the judge not seeming to care about the defense's allegations that the prosecution was tampering with their witnesses or telling their witnesses not to show up. It's saying it's not working here on Facebook, but I will try to do that later. For now, how do I just get out of this? There we go. All right. So we're going to talk about this case today. It's going to be fun. It's going to be interesting. It's going to be hopefully an opportunity for us to learn and discuss some of the intricacies of what happens when you try to disqualify a judge and what the bar is and how often it happens. We'll talk through all of that because these motions very rarely get granted, but it is still an interesting conversation. So we will talk about that and answer your questions, of course, at the end. But I do want to kind of go through this motion to see, what did the defense actually say? What did they quote from the hearing that we've already discussed together? And then, very interestingly and importantly, we are going to hear from Nikolas Cruz, the criminal defendant in this case, who is not going to testify, but he did fill out an affidavit as to his feelings towards this judge and how he feels this judge is dealing with his case. And that is signed under oath. So let's get to the amended motion to disqualify. All right. So here's the amended motion to disqualify. I see somebody say the motion was already denied. I don't know if it was denied or not. It wouldn't surprise me if it was. But they discuss how the defense counsel and the judge have gone back and forth. They go through some of the quotes from the hearing that we watched together. We don't have to belabor this, but the court, they bolded, was said that the defense has been insulting her the entire trial blatantly, and quite frankly, this has been long overdue. She hammers at the defense a little bit. I will say, not great. You don't want the judge to do this. You want the judge to stay calm as much as possible, but I have heard much worse in court and at trial, and those judges haven't gotten disqualified. I've also heard it happen to lawyers that, in my opinion, absolutely deserved it. And some people think the defense in this case did deserve it. I think they deserved a stern talking to. I think the judge, if I was the judge, I wouldn't have done it. I'll just tell you that. So people are always going to ask me, what would you have done? I would not have done it. If I was this judge, I would have just said, you rest? Okay. All right. We'll wait till tomorrow then, and just move it along. This is not your case to try. You don't represent anybody. If you're frustrated with how they're treating the jury, I understand. But it's not going to change the recess. It's not going to change the fact that we're going to wait a couple weeks for the state's rebuttal case. It's not going to change anything by going after these lawyers. And I don't want to create an issue for an appeal if I am a judge. So I would have just let it slide and then continued going. Then, here are the important quotes, paragraph 7. After bringing in the jury to allow the defense to rest, which the defense actually rested outside the presence of the jury, this feels a little disingenuous in certain parts of it. The court discussed scheduling issues with the jury, and the court stated, so we did not anticipate that the defense would be resting today. Therefore, the state is not prepared to go forward with the rebuttal case until the 27th. I don't understand why that matters if the defense rested today or tomorrow or the next day, why the state needed 2 weeks to prepare for their rebuttal case. But I understand scheduling witnesses sometimes is difficult, but you can't change it from a 2-week period of time. Either way, then the judge said, you see the little ellipses there with the stars. A lot was said in between, as we know, because we watched the hearing together. If I had known earlier that this was going to be happening, I would not have dragged you all in here. Now, the very important part that is cut out of here is when the judge walked it back and took responsibility for the scheduling errors. So again, I don't think this is fair. I think it's fair for the defense to put that first part in there and say the judge absolutely blamed the defense. That's fair. They can make that argument. They can try to get her disqualified based on that. But then to pull out the middle part where the judge takes responsibility, which the defense does admit later, they put in there, if I had known, I wouldn't have dragged you all here. Judge took responsibility. Okay. And then here we go. Although advising the jury that it was at fault, meaning the court, for any scheduling problems, the court clearly placed blame for the jury's inconvenience on the defense. I disagree. The court undermined the defense by insinuating to the jury that the defense did not provide the state or the court with information it should have in advance. And as a result, they came to court unnecessarily and will now have to wait almost 2 weeks to return for the state's rebuttal case. That is patently false. The defense had absolutely no legal obligation to advise the state or the court in advance of its intention to rest its case. That is correct. But they didn't have the obligation to affirmatively say they were going to do something and then not do it. That's kind of my bigger issue with the defense. Absolutely within their right to rest their case, but that's it. It's over. If people get mad, they get mad. Whatever. They're representing their client. But you don't want this stuff to happen in front of the jury. Moreover, the jury has to be present for the defense to rest. That's true too. Finally, the court tied itself to the state when it indicated we did not anticipate and therefore the state is not prepared. No, that's a stretch. Although the court is in line with the state most of the time, so that's a fair argument. In essence, the court blamed the defense and gave the jury an excuse for the state's inability to move forward for nearly 2 weeks. One of the things I had a problem with is the judge almost made it seem like the defense wasn't supposed to rest. Like they should have called more witnesses and they didn't. Maybe even they should have called Nikolas Cruz and they didn't. That was one of the other issues I had, is it wasn't just that they're blaming the defense for this delay, but also was the judge insinuating we should have done more for our client? We should have had more evidence that we didn't put on? That's why you just can't say stuff like that as a judge, in my opinion, and why I wouldn't have. The court's statements criticizing and chastising defense counsel and blaming the defense for the jury's inconvenience have caused Mr. Cruz to reasonably fear that the court is prejudiced against his lawyers and him, and that he will not receive a fair and impartial trial going forward. Okay. Now we've heard about, this happening throughout the case. There was an interesting point I wanted to talk about here. Yeah. There have been several instances where the court has shown animosity toward defense counsel that are now cast in a new light. Although prior comments cannot be used for a timely basis for disqualification, that's correct. We see no reason why they cannot inform a defendant's understanding. Gosh, this Facebook thing is really annoying. There we go. All right, so September 2nd, 2022, prior to the commencement of trial, the state and defense agreed at the end of each day they would provide opposing counsel a list of the witnesses they were going to call. That makes sense because they can prepare for them, they can call them, they can prep the cross-examination, so we understand how this process works. However, that agreement was honored by both parties until September 1st, when the defense terminated the agreement, believing that it would be ineffective representation to provide the state with the names of the witnesses intended to call in advance based on prosecutorial misconduct in tampering with a witness. See paragraph C below. On September 2nd, when the defense attempted to call a Zoom witness, a platform used throughout the trial, the state objected. During a sidebar conference, the state indicated that the defense had refused to honor its agreement to disclose witnesses the day before, and as a result, the state would only agree to allow a defense to use Zoom if the court ordered that the state would be permitted to use Zoom during its rebuttal case as well. The court then stated, I need to know exactly what you're agreeing to in no uncertain terms and make sure your client is in agreement too, because I, quite frankly, understand the state's concern at this point. I disagree with the judge here again, which is interesting. So the defense says, we were agreeing to tell everybody, here's who we're going to call, until we found out that the state was calling our witnesses right before they take the stand and trying to pressure them not to testify. And that's what the defense said happened. Did it happen? Who knows? I didn't think the judge's response to the defense's objection there was very good. She obviously, I mean, to me, it seems like she just doesn't believe the defense attorneys, because if that happened to me and one of my witnesses, and I said that the other side called them and tried to tell them they had some concerns about their testimony, and the witness said they were uneasy about testifying, I would burn that place to the ground with my arguments. Maybe that's not a good reference, but I would pound the table with my arguments about that attorney misconduct, and I would definitely not tell them what witnesses. So I have no problem with the defense doing that. And the reason for this whole like Zoom takes backsies is they all agreed to call the witnesses by Zoom. But that now the state's saying, well, you broke one of our agreements with the witnesses. Now we're not going to agree to anything. Now we need court orders for everything. Again, very kind of ticky-tacky, like little kids, and the judge has to make a decision. And then the judge, again, kind of goes off the defense again. Here's the deal. It's either all or nothing, the judge said, which is totally inappropriate. You do not have to agree to all or nothing. And I think it's interesting, right? Because if the judge has already agreed to something, the attorneys had already agreed, and then we pull something back because of what the state did, and now the judge is saying, well, all of your agreements are off now. That just prejudices the side that feels like they didn't do anything wrong, which would be the defense here. Not saying it's true, but I'm saying the defense thinks there's prosecutorial misconduct, and now all the deals they had with the prosecutor are off unless they go back on that. To me, that's unfair, personally. And again, this is something that if I was the judge, I'd be like, yes, you can call the witness by Zoom. It doesn't have to be hard. It doesn't have to be a fight about everything. And again, if the judge wants to stick it to the fence, that's her prerogative. But in my opinion, I would say, state, sit down. Yes, you can call a witness by Zoom, defense. That does not affect the case. That does not affect justice. But if you say, no, you can't call them by Zoom, that could affect justice, because now they might not be able to call the witness if it was all planned by Zoom. So, that's the issue I have with that. The defense lawyer may be being annoying. She may be making things difficult on purpose. If you all want to argue that, that's fine. I understand that. But as a judge, I would want to keep this case moving and try to avoid appeal. Court made more statements chastising counsel, both counsel, but looked directly at defense table. And then they say we have video evidence when she's pointing at the defense when she says some of this stuff. That's when they asked for the affidavit. All right, let's get to the argument a little bit. Oh, she says that the judge threatened to reprimand defense counsel in front of the jury after a heated sidebar discussion, regularly admonishes defense counsel when more than one attorney attempts to participate in an argument while allowing the state to do that. That's something a lot of judges get on lawyers for. Only one lawyer can make arguments most of the time unless the judge allows it. Reprimanding them for speaking even in a low volume while in recess, but in the courtroom while ignoring the prosecution doing it. Sounds very petty here. Refusal to allow the defense to address issues when the jury is waiting to come into the courtroom while allowing the state to raise any issue it chooses at any time. So basically playing favoritism with the state. And I will just say most judges do that. They lean that way. I don't know if this judge was a former prosecutor. A lot of them are. But let's look at a little bit of the argument here. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer or a personal knowledge of disputed evidentiary facts concerning the proceeding. So I don't think the judge is going to admit that she has a personal bias here, or I don't even think she does. I think she is frustrated with how they're acting in the case. Let's see what else. The duty to hear all proceedings fairly and with patience is not inconsistent with the duty to dispose promptly of the business of the court. Judges can be efficient and businesslike while being patient and deliberate. I agree. And I think being patient and deliberate are two of the best and most important qualities of a judge, perhaps above legal knowledge. If you can be patient and deliberate, now deliberate, you need the legal knowledge to be appropriately deliberate in making decisions, not letting stuff just continue, not leaving stuff hanging, not deferring rulings. Be deliberate, make a call based on the information you have. Make sure you have all the information, of course. But to me, those are two of the most important qualities a judge can have, is patience and being deliberate. They talk about the motion is legally sufficient, then it focuses on the reasonableness of the defendant's belief if he or she will receive a fair hearing. So is it legally sufficient? Is this motion legally sufficient? They argue it is. I would argue that the judge is going to say it is not. Cat's already out of the bag. I think if it hasn't been denied already, the judge is going to deny this and keep the trial moving. But they mentioned some cases here in case law where the judge reprimands the defense outside the presence of the jury, then threatens to do it in front of the jury, which apparently happened in this case, blames the defendants for problems in the case, admonishes the defendant, chastises the defendant or his defense team in front of the jury at all. All right, but interestingly enough here, let's look at the affidavit in support of the defendant's motion to disqualify. These are Nikolas Cruz's words. So something that's interesting to me, and let me know in the comments. Do you think Nikolas Cruz wrote this, or do you think his lawyer wrote it? As we read it, let me know. Because if you've heard about him and seen some of the stuff he's written in the case, do you think he wrote it or his lawyer wrote it? Not that it makes it, your lawyer is allowed to write it after talking with you. They write the affidavit. It's just very interesting sometimes when this happens. I am the defendant in this case and have pled to 17 counts of premeditated first-degree murder and 17 counts of premeditated murder in case number X. I was present for trial September 14th and have been throughout the entire trial. I observed the following and have discussed it with my lawyers. On September 14th, 2022, after my lawyer, Melissa McNeil, told the court that we would be resting our case, she didn't say, Judge, we will be resting our case, which I've done a million times. She said, Judge, the defense rests. So she tried to actually rest her case, not tell the judge she was going to rest her case, which is the problem. Because if you remember the hearing, the judge continually asked, who's the next witness? Who's handling the next witness? How are we getting these exhibits in? What are you guys doing? Why won't you answer me? Judge, the defense rests, right before the jury came in. So they're trying to act like in this motion that they were trying to do it the appropriate way and keep the court and everybody, knowing what's going on. And it just wasn't the case. And they didn't wait to rest their case. They didn't inform the court or the state they're going to rest their case. They didn't plan on resting their case. They rested their case. The court said, quote, I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this. And even if you didn't make your decision until this morning, I have 22 people plus all the staff, every attorney, march into court, be waiting as if it's some kind of game. And now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced this level of professionalism in my career. It's unbelievable. The court's statements cause me to reasonably fear that the court is biased against my attorneys and me, and I will not receive a fair and impartial trial. The court also revealed that her feelings toward Ms. McNeil extended throughout the trial by saying, see how he's connecting all these quotes? What a good job by him. You have been insulting me the entire trial so blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue, so please be seated. Now, I will just say, this was said outside the presence of the jury. If this was said with the jury sitting there, this judge needs to be disqualified. And it does show that she's been annoyed with how the lawyer has handled the entire case, but that happens sometimes, and judges do feel that way. The court statement caused me to reasonably believe that it has disliked my attorneys throughout my trial, and it is biased against me and my lawyers, and I will not receive a fair trial. The court has repeatedly insulted my lawyers throughout the trial and has caused me to believe it is biased against me and my lawyers, and I will not receive a fair trial. The court made the following statements about my lawyers, further causing me to believe it is prejudiced against me and my lawyers, and I will not receive a fair trial. On September 1st, 2022, the court said, this whole situation here has become unprofessional. I don't want any further rude or disrespectful behavior. The court was pointing at the defense table and stating your client at the time. Also on September 1st, the court brought the jury in before Ms. McNeil was present. I believe the court did this to embarrass defense counsel and make a point to the jury that the delay was only caused by defense counsel. I have reasonable fear that the court was attempting to poison the jury against my defense counsel and me, and that I won't receive a fair trial because of the court's statements and actions. Now, I didn't know that. That's interesting. I didn't know the court brought the jury in before defense counsel was there. Now, I know he's got a bunch of a bunch of lawyers. I get that. But I would have a major problem if the judge did this, especially in a criminal defense case, because there is a constitutional protection and right to have that defense attorney there. So that is a problem, just FYI. I know a lot of you hate on the defendant and the defense, and that's fine. I'm just going to stick down the middle like I usually do. September 2nd, the court stated, I need you to say exactly what you're agreeing to in no uncertain terms and make sure your client is agreeable. The court dismissed my lawyer's reasoning for revoking the witness disclosure agreement, which was that the state had tampered with one of our witnesses. The court further commented, well, I just said to you, here's the deal. It's all or nothing. Again, the court further demonstrated prejudice towards my attorney. We already read that part. Again, there's a Florida administrative order that allows Zoom testimony. I agree. I already kind of talked about that. The court's actions caused me to reasonable fear that the court is biased against my attorney. September 13th, my lawyer advised me that at sidebar, the court threatened my lawyer that it would reprimand my lawyer in front of the jury by stating, I'm going to reprimand you in front of the jury. The court's statements caused me to reasonably believe it's not going to be a fair case. Therefore, there has been continuous disparaging comments and actions from the court, including but not limited to admonishing my lawyers when more than one attempt to participate in an argument. Again, he's just reiterating what the lawyers already argued. Negative and disparaging nonverbal actions throughout the trial, including rolling her eyes when my lawyers are speaking or wish to speak, turning her head in a dismissive manner when my lawyers are speaking or trying to speak. What did they say? 90% of communication is nonverbal. These nonverbal actions cause me to reasonably fear court is biased. Because the animosity the court has had towards my lawyers throughout the entire trial, I feel I'm not going to get a fair trial, especially from Mr. McNeil. Also, the fact that Judge Shearer used to work for the state attorney's office. Hey, there's the answer. She used to work for the state attorney's office and continued to have relationships with people from that office. Makes me think she's biased in their favor and against me. For this reason, I don't believe I'm having a fair trial. Now, if this was the case, just about every judge that handles criminal cases would be out and recused because most of them work for the state attorney's office or the public defender's office, but mostly from the state attorney's office. So no surprise there. I'm prejudiced by Judge Shearer's actions and words. I don't believe the judge will perform her duties impartially. I'm seriously concerned about the judge. It's a well-grounded fear. Okay, so let's talk a little bit, and then in a few minutes, if you all want me to, there's about a 5-minute clip about the defense making the argument as to why the state tampered with their witness, and you'll see how the judge responds there, which, again, I don't really love it. I understand the judge getting frustrated. Don't take that lightly. I understand the judge is getting frustrated, but let's answer a couple questions. BW, how could a judge who has been a former prosecutor not be biased in this case? Well, they have to swear an oath when they become a judge that they're not going to be biased. And I will just tell you, sometimes it's easier than others because in certain circumstances, think about it this way. Imagine if you're Nikolas Cruz and you feel this way and the judge is interacting, like if this is you, okay, and you don't think you're guilty or, it's a different case than Nikolas Cruz, I get it. But let's say you're being prosecuted, you don't think you're guilty, and this judge is acting this way towards your lawyers. And this judge used to work for the state attorney's office. But listen, it's in the jury's hands, right? But let's say a jury comes back guilty and now the judge is deciding your penalty and deciding your sentence and your punishment. I'd be scared. She's going to hammer me. She's going to give me the max. She hates my lawyer. She hates me. That's why this type of stuff should not come in during trials. It really, really shouldn't, in my opinion. It's okay to get frustrated as a judge. She's human. Try to keep it out as much as you can. Be patient. And what was it? Determined? What was it? I can't remember. All right. Azam, I'm confused. Is this the penalty phase trial the same as sentencing? If not, how to tell the difference? So there is no real sentencing in this case. This is determining his sentence. So it's a good question. Usually, try the case, win or lose, great. Jury decides, and then the judge decides the sentence. The jury is deciding the sentence in this case. The judge is not deciding the sentence. The judge is really not doing a whole lot, except for obviously calling balls and strikes and keeping the case moving. But the judge is not determining the sentence like they do, patient and deliberate. Thank you, Melisasi. I knew somebody would get it for me. Patience and being deliberate. That's what you need to do. So Yes. So the penalty phase and this, sentencing phase, it's all wrapped in one, and the jury is going to determine whether his sentence is life or death. Those are the only two options. Gabrielli Garcia is a new member. Awesome. We're going to have a members only chat. I don't know if we're going to do a video or a members only chat during a video. However, we do that this week. And I think it's going to be, I don't know what it's going to be about, but we are going to do one this week because I'm going on vacation Wednesday, but I'm going to do a couple of videos at an undisclosed location that's supposed to be beautiful in the exact opposite of the 100-degree weather it feels right here, right now in Tampa, Florida. I am going to do a video on the Sins of Our Mother Netflix documentary, and then I'm going to do a members only type video. So just wanted to mention that, and thanks for joining. Just BKZ, another member here. If the defense spoke to the judge first, expressing concerns regarding witness tampering, do you think she would have been more willing to bend? Absolutely not. That is not how you handle it. You don't go to the judge ex parte outside the presence of the state. You give the state their opportunity to defend themselves. You say it on the record in open court. You have to say it on the record because it protects the record. You can't say it just with you and the judge before the court reporter's there. You got to say it on the record. It's got to be official. Everybody's got to know that you have an issue that there may be witness tampering happening. April said, oh my gosh, that documentary. Billy said, I've been watching it. It's very interesting. Nick said this case will be appealed. Well, there's automatic appeals if he gets the death penalty, so we don't have to worry about that. Linda F. is joining the conversation here as a member. Max Sauce, yes, Sins of a Mother is intense. I'm saving it for the plane ride, so I haven't watched it yet, but I'm downloading it all on Netflix, and I'm gonna watch it on the plane ride with my wife. Oh, court is back at 3 p.m. for hearing of motions. Well, that's interesting. I have an appointment in about 40 minutes, so we'll see. Why don't you guys let me know if they start actually? I'll probably have to break it down later, more likely than watch it now, especially with all the beginning that they're going to be doing. Let's see here. All right, let's go ahead and watch together this clip of them arguing about the witness tampering that happened September 1st, I believe it was. Let's jump into that here.
Okay. Is there anything else? Okay.
Judge, the defense is respectfully requesting a 24-hour recess. During lunch, we were downstairs pre-trying our afternoon witness, Mr. Jack Vasey, who is the vice principal of what.
So right now it's the trial court judge determining whether the trial court judge should be disqualified.
West Glades Middle School. And during that pretrial conference, we were advised that this morning, the morning of his testimony, he received a phone call from Christopher Whitelock. Christopher Whitelock is an attorney here in Broward County. He represents Jeff Morford, he represents Ty Thompson, he represents other members or other employees of the district that were working at MSD at the time of the.
Katie, I agree with you. Interesting, though, the state has nothing to appeal when they lose a criminal defense trial because can't have double jeopardy. So interesting. They can't really appeal for that. They almost never win for something like that.
During the conversation, and Mr. Vasey is a personal friend of Mr. Whitelock's. During that conversation that Mr. Vasey was having with Mr. Whitelock, he called Mr. Marcus and three-wayed him on the call where Mr. Marcus was interested.
So you see how she looks at the prosecutor? This is a tactic sometimes lawyers do because they think it's intimidating. I don't know her personally at all, but this has happened to me where they look at me and I usually just give them a look like this. Like, why are you talking to me? You should be talking to the judge. I'm not making the decision because I know what decision I would make.
Introduced as the state attorney in the prosecution of Nikolas Cruz. And at that point, Mr. Marcus and Mr. Whitelock advised that Mr. Marcus was a friend of his. And then they said to him that they had concerns about his testimony today and how it could impact the district and how it could impact the individuals that work for the district.
Talk to me, please.
At this point, Mr. Vasey
Talk to
felt
me.
very nervous and very uncomfortable, nervous like any witness that's coming in here to testify after this phone call, and he got the impression he felt like they were trying to prohibit him from testifying. So based on this, the defense is asking for a 24-hour recess. I have secured an affidavit from Mr. Vasey. We need to file a motion to disqualify or to prohibit the imposition of the death penalty or the state seeking the death penalty based on prosecutorial misconduct, and we will be seeking remedies. We're not exactly sure what those remedies will be, and then we will be consulting to see if who we need to talk to, if it's an outside prosecutor's office, to investigate the possibility of witness tampering. This gentleman was forthcoming and told us this morning. We haven't been asking our witnesses if they have in fact been contacted by the state attorney's office about what they were going to testify and the implications of their testimony. But we are aware that this happened this morning, the morning of this gentleman's testimony. So the defense needs opportunity to file pleadings. So we're asking for a 24-hour recess, please.
Okay, that's denied.
Okay, Judge, I need 20 minutes to go downstairs, please.
So theoretically, she just denied taking a 24-hour recess. I'm not sure she totally denied that there was any wrongdoing, but she doesn't seem to care at all that the state did this, which is frustrating to me because judges do that a lot, where the state attorney will do something that if the defense attorneys ever did, they would be appalled, but because it's the state.
I'm telling you that the defense believes that the state of Florida.
I
has
understand
committed
what you're
prosecutorial-
saying, but there's no reason why we have to recess for the day. There's no reason we need to delay. You have all of next week to file it. Why can't, what's the difference between filing it right now, this minute, and next week?
Because Judge, it's a motion to prohibit the death penalty.
I
We need to
understand that.
focus on that. I mean, I'm sorry, I would assume that you would be outraged by this conduct, like the defense is, and we just need an opportunity to review all the information.
You can do that after court. You can make the motion now, I'll defer on it, and you can file your pleading at a later time.
Judge, I'm asking for 20 minutes, so I can go back downstairs to my office.
Your Honor, I feel compelled. This is totally not true. I did have a conversation. I called his lawyer, asked him if I could speak to his client, and we spoke about what his testimony would be. Mr. Whitelock heard the conversation. I have every confidence Mr. Whitelock would think it was an appropriate conversation. It was merely what are you going to testify to, and some questions about his role as principal.
So that's where the distinction lies, because if that's all he said, totally appropriate conversation to have with a witness before they testify. Totally appropriate. But if he said, we're concerned about your testimony, or, try to do anything to make him not testify, that's a major problem, because this is the state attorney's office calling you. If you're already scared to come and testify to somebody that the world basically hates as a criminal defendant, that would be nerve-wracking. And then the state's putting pressure on you. We cannot have that in our criminal justice system. I think all of you would agree. So if it's the way that the defense attorney is saying, this is a major problem. But if it's the way the prosecutor is saying, where he just said, what are you going to testify to? That's totally fine. And people do that all the time.
Absolutely untrue.
Okay, I'm denying the request. I'm not continuing the matter. We're going to go forward, and you can file whatever motions that you need to file.
Your Honor, I'm asking for 20 minutes to go downstairs to my office, please. I'd also like to give the court the signed affidavit from Jack Vasey. I understand that Mr. Marcus is in disagreement with what this witness is saying.
Okay, we're in the middle of the witness, Miss Yon.
No, I
We have a
understand.
jury waiting. I want to finish Miss Yon.
So here's what I'm going to say real quick. So they're saying they're in the middle of a witness. So what she's saying now, she wants the defense attorney to wait until after this witness. Then would she have been mad at the defense attorney for saying, well, why didn't you let me know as soon as you knew this? It's hard to sometimes as an attorney when a judge is really on you, because whatever decision you make, they can pick apart, because they can say, why did you wait 3 hours to tell me something this important like witness tampering? It's like, Judge, we were in the middle of a witness. But it's also fair for the judge to say, let's finish this witness, then you can take your break, which I think is what the judge ends up saying.
We'll take a recess after her testimony, at which time you can feel free to go down to your office. We'll take a 15-minute recess, and you can go there then. But I'm not going to hold up Miss Yon or the jury at this time. I want to finish this witness.
That's fine. Then I can write down after this one.
All right. So that was the end of that. Let's get to some more questions here, because there are some that I do want to talk about. Before we get there, Nicole Wheeler is playing Oprah Winfrey here and throwing out memberships, I believe. to Darcy and Valerie and AK-47 Mouth, which is awesome. Cheryl is a new member as well. Really cool of Nicole and everybody to join. Maharaja said the inherent bias in the justice system against defendant is completely unfair. I 100% agree with that. Brianna CC, what's up? She said the witness later testified that he felt uncomfortable after the exchange with the state for whatever reason. That's problematic to me. And I didn't see that witness testimony or what he said about it, but what do you guys think? Here's a question. And you may know just by the way that I'm asking it, but answer in the question or not. If you are going to be a defense witness, a witness in a criminal defense case for the defendant, and the state attorney calls you and wants to talk about your testimony, do you think you have to talk to them? Now, a lot of you may not, because you're crime buffs, you watch these trials, you understand the process more than your average person, but you do not have to talk to the state at all. You can absolutely say no, and there's nothing they can do. If they subpoena you, if they say you're coming for your deposition, if they subpoena you to come to trial, you have to show up and talk to them. But if you're a defense witness, you do not have to tell the state what you're testifying to. You don't even have to take the phone call. What you should do is not take the phone call, call the defense lawyer on the case, say, hey, the state called me. Do I need to talk to them or not? And see how that works. We represent victims in a lot of cases, like especially DUR, car crash. Our case can be a victim in the criminal case. They can talk to the state. They don't have to. They can talk to the defense lawyer. They don't have to. And they have us representing them already on the civil side. So we advise them in those situations. But to me, it's problematic because, you know, it's not something you have to do, but it can feel like you have to do it. All right. Tori, what do you think about, or what do you think the defense's strategy was in wrestling the case the way they did? If you answered already, I missed. Good idea or bad idea in your opinion? So this isn't possible for me to know because I don't know what evidence they had and what evidence they didn't show, right? If they didn't have anything else they felt was beneficial, I think it was fine to rest their case. I don't think they should bore the jury or just put a bunch of nonsense up there as evidence or testimony. If it's not going to be important to their case, I don't think they need to show it. I don't think they need to play it. Okay. So that's one of the important parts about it. If they did have better evidence, but they got impatient, bad move, right? So, I mean, that it all depends on what they had. Mystic Firefly. Perhaps McNeil should not be in this judge's courtroom if she has an ongoing personal problem and cannot keep it separated from a professional hearing / judge. If that's the case, and this does happen from time to time, if that's the case, they need to know that at the beginning of the case. And she should go to a different courtroom. If the client has the opportunity and the availability to have McNeil as their lawyer, if McNeil is their lawyer, then this judge could recuse herself from all of McNeil's cases if she wants to. That is possible. So Mummy said, I understand the judge getting frustrated with the complaints and the delays, but I don't think her manner is in keeping with other judges. Valerie, so do they have to do this all over again, or will it be a mistrial? I don't think it is going to be a mistrial. I don't think the judge is going to recuse herself. I don't think we're going to have to do this all over again because of any of these issues. Now, an appellate issue might come up that they have a good appeal. I don't know. It's too late to do it now. So Brandon, not technically, not legally speaking, it's not too late, but I understand what you're saying. Yeah, Leah asking why it's taking so long to make a ruling on the motion with the racist and derogatory things that he wrote down. I hate that. I wish I could remember determined. Gosh, I can't remember what. Deliberate, patient, and deliberate. That's what the judge needs to be. Patient and deliberate. They need to be deliberate. They need to be able to make these calls. I think she should have already made the call by now, whichever way. I mean, I think she's going to let it in. I mean, I thought I heard her say she is going to let it in. Let's see what else. Some people saying I'm not super impressed with the judge. A lot of people saying they don't think the judge is acting appropriately. They don't think the lawyer is acting appropriately. When there are cameras, you see it all. You know, you see it all in the courtroom. And I think, yeah, maybe Cruz wanted the trial to end, Kylie said. That's true as well. And yeah, putting the victims' families through all this is horrible. I mean, it's just absolutely horrible. And at the end of the day, it's going to be over here at some point, and hopefully everybody did enough that whatever the jury's verdict is, it's a one-shot deal. We don't have to do it all over again. There's no overturning this case on appeal or anything like that. That's really what I hope at the end of it. I hope the jury makes the call the jury feels comfortable with and that the evidence points to. And then I hope it's not overturned on appeal and we have to do this all over again. Yeah, people saying they think it should be death. They think it should be life. Totally understand all of that. All right. So this again was sent to me by email and on Instagram and Twitter. At Tragos Law is my Instagram and Twitter handle. If you want to follow us on there, hit that subscribe button if you haven't already. I don't think I've told you guys to like the video. If you haven't liked it, like the video already. Sometimes I forget all of that stuff. But this trial is really interesting and it's not going away. We'll see what happens during this hearing and what decisions are made if we have to do anything else. There will be a live tomorrow. The topic is still up in the air. So comment below what topic you want me to do. Go to the community page if you're a subscriber to the lawyer you know, and let me know what content you want me to do my video on for tomorrow. And then, like I said, we've got a couple of interesting ones planned later in the week. Thank you, Azam, for the super sticker on the way out. You guys are all the best. As always, I'll let you get to that live hearing. If you all want to watch it, I have to get to my appointment. I appreciate everyone, as usual, jumping on here. It was a lot of fun to discuss even a very depressing and challenging case, because discussing it and learning it together and getting input from people that could be potential jurors is always fun for me. So I appreciate you all as always. Until the next one. Oh, before I go, there is a fun short coming out on the Heard v. Depp, actually Heard insurance case from the video I did the other day. If you didn't watch it, keep an eye out for that short. The edits on these shorts are kind of fun and kind of cool. They're a different kind of viewing pleasure and production with some of the stuff we're trying. We did one on this case already. Let me know how you guys like those shorts and that kind of extra production and stuff. If you think it's fun, let me know. We'll keep doing it. If you don't care about it, then maybe we'll stop. But I appreciate it.